presentation.
Ms. Smith, would you do the prayer, please? And Mr. Silver, would you do the pledge?
I'm not reversing it. Yes. Our Heavenly Father, we come before you this afternoon. We want you to continue to bless us and keep us and lead and guide us in this world. We want to thank you for being so good, being so kind. Thank you for walking with us today. Thank you for our health and strength. Our Heavenly Father, we want to remember Mr. Lewis Marshall and his family, the death of his brother last week. Our Heavenly Father, peace and understanding, let them know your God and able to keep them from falling. Give us the wisdom and knowledge to carry on this meeting the way that you see fit. These blessed thanks in Jesus' name. Amen.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, Ms. Fields.
Mr. Lawson.
Certainly.
Mr. Fowler.
Here.
Mr. Johnson. Mr. Smith.
Here.
Mr. Silver.
Here.
Mr. Hobbs.
Here.
Mr. Marshall.
Here.
Mr. President, you have a quorum. The first item is to hear a presentation from Charlie Breaux from the Attorney General's Office on open meetings law.
You got it, Mr. Bro.
Mr. Marshall, this is Charles Breaux with the Attorney General's Office, and he's here to make a presentation.
Thank you all for inviting me over here to give you all a little, perhaps, instruction or refresher course on open meetings law. As y'all may know, the legislature just finished meeting today. A lot of bills dealing with ethics, dealing with public records, dealing with public officials, dealing with lobbyists. And our office has been charged previously with the enforcement of open meetings laws. And so we're taking the opportunity to go out and talk with various boards, commissions, councils, general public, just to advise them that there are open meetings laws that are on the record. These laws are for the use of the boards, but also for the use of the public, so that we are, as they kept using the term in the legislature, transparent. You know, we live in a society now that a lot of things have to go on in the general eye. In fact, for the first time that I ever saw the legislature, instead of these meetings that they had together to form out, compromise these things, they had these meetings in the public for the first time that I'd ever seen them since I've been working with the legislature. So with that in mind, I would just like to perhaps begin with a handout, if you would help me here, just for these people, and then I'll have some extra for the public.
Make it the ideal setting for a thriving economy. An economic centerpiece of our proud history and promising future is Oakland Airport.
Okay, Louisiana's open meetings law. Louisiana's Constitution provides under Article 12, Section 3 that no person shall be denied the right to observe the deliberations of public bodies and examine public documents except in cases established by law. The body of law that I'm handing out here is called the Open Meetings Law, and these are the rules that the legislature has determined in order to make these public bodies open to the public, so that we have some, as I again say, transparency. Section 5 provides that every meeting of a public body shall be open to the public, except when closed according to law. Just so they can do it, I handed them all out. But if you go back to the definitions, there's only a couple of definitions. They say a meeting. Meeting means the convening of a quorum of a public body to deliberate or act on a matter over which the public body has supervision, control, jurisdiction, or advisory power. It shall also mean the convening of a quorum of a public body by the public body or by another public official to receive information regarding a matter over which the public body has supervision, control, jurisdiction, or advisory power. Now, I was talking just before the meeting with Mr. Gist here, and we were discussing something that the council may have to do with one of the judges here. And we talked about that. Well, that would be a meeting of the body to gather information. You know, we talk about people going on retreats. Well, boards can go on retreats, but you have to notice the meeting that is going on a retreat, and you say for what purpose, and you have an agenda just like other things. Okay. Of course, that may not be one that we go on these silent retreats. I guess that probably wouldn't cover it too much. Okay, so we have meetings, we have public bodies. Now, one of the exceptions, of course, is where you can just go as a body by saying, okay, well, we're going to go to see the theater, see a play, and we just happen to go, like a social function. Well, you're all there. That would not be a meeting, okay? But there are a lot of other things that say, oh, I'm just going to, say, the parish council. They're discussing something that we're interested in. Well, if you go as a quorum, say 4 of y'all go, or if you send one of your committees that you have a standing committee, then a quorum of that committee to gain that information, that would be a meeting. So you know, you're going to have to take it down the pyramid a little bit. One of the things, you know, if you have a standing committee of 3 members, well, 2 of those 3 is a quorum, so they need to follow the open meetings laws. All right. And again, it says, part of that in section 4 says it shall not apply, public meetings law shall not apply to chance meetings of social gatherings of members of a public body at which there is no vote taken, including formal or informal polling of the members. Recently, we had a problem in our office with, this is in Lafayette, and we had one of these airport commissions that was meeting. And then after the meeting, which is all fine, they would go to a steakhouse. And a quorum of them would get together there, and they kind of probably were talking business. The reason why we thought they probably were talking business is that they were using their credit cards from the thing and writing off that it was a business expense. So it was a kind of problem that you said either you were or you weren't. So what happened, the district attorney and I and our office basically made them refund those payments, et cetera, to the thing to make sure that it's going on. But these are the things that y'all need to realize, that this is, you know, if you were meeting at the steakhouse, that's okay. But, you know, you should have noticed that we're going to have a second meeting at the steakhouse. All right.
You have to follow the same procedure of 24 hours advance notice and that stuff?
To be right, yes. Now, they're called for emergency meetings, and you can have an emergency meeting, but it should be an emergency. So the reason for the 24-hour notice, of course, is for the public. And now, if for some reason you even have an emergency meeting and you tell all your councilmen that we're having this meeting such and such, then if the press has requested to be notice of a meeting, you have to notify them in the same manner and same form that you're notifying all the board members. All right, and of course, I don't see it here.
It's on the outside door.
Okay. All right, but the public should know that the reason is we have a copy of these open meetings laws should be posted on where the meeting is taking place, so that the public has a right to go out there and say, I'm not sure they're doing this right. So anyway, that's one of the things that was recently passed, I guess about 8 or 9 years ago, that a lot of people don't realize. I represent boards and stuff, and I have to tell them all the time, why don't you put this up? You know, this is what the law says you're supposed to do. All right. Let's see. The biggest thing we talk about, executive sessions. All right. That's under section 42, 6.1. And if you look at there, it goes through about 10 or 12 reasons that you can do that. And I will tell you this, our office will look at this when we get complaints. Our office is going to look at this, because this is where about 80% of the complaints come in. And we're going to look at this. If you can fit what you're doing, attorneys, other people, if you can fit what you're doing into one of these 10 lists, we're not going to have any problem. If it doesn't fit, and I mean pretty good fit, I mean, you know, we're negotiable. We are attorneys out there, so we can play with words and stuff, but if it fits in here, you can do it in executive session. Now, one other thing that you can go into executive session that's not listed in here, but it falls under section 10. It says any other matters now provided for or as may be provided for by the legislature. Well, here's the other thing.
Our first few didn't get in there.
Article 1, Section 5 of the Constitution says you have a right to privacy. All right. If you're going to be dealing with personnel, licensing, some kind of thing that you as a board or as the general public would deem confidential, you may go into executive session for that. In fact, you're probably required by law to go into executive session to deal with this confidential nature. What you have to do, of course, to go into executive session, you should put it on your agenda if you know about it in advance. If you're going to be talking about personnel, what you have to do is notify that person that you plan on going into executive session, discuss something about them, and then that person uniquely has a right to say, no, counsel, if you're going to go into executive session, I would rather it not be done. I would rather it be an open session. And that person can prohibit that executive session from taking place if they require that it be open to the public for that discussion. Now, you know, if you're dealing with a promotion of some personnel or something, it's not likely that's going to happen. But it's there, and it has been done before, because I've seen it done here in West Baton Rouge Parish, as a matter of fact.
School board time.
Any questions on that? All right. Once again, posted a notice must be of the agenda, et cetera, at least 24 hours in advance at the public place. In addition to this, I guess y'all posted on the notice on the door of the building, the town hall. And then do y'all have a regular session where y'all post where your regular meetings are in the record and everything? That's fine. All right.
Where,
Yes, sir.
I know there's been some discussions, just kind of, I guess, quasi what you're talking about with the public meeting notices being, maybe the minutes being published online. Is there any discussion about that again in lieu of the record of journal or journal of record?
I know that minutes have to be published, and I know there's been some opinions that our office has written, but it might even be some case law that says that a clerk is required to publish the minutes within a reasonable time. We had a problem, I think this was in Lafourche Parish several years ago, where the clerk would not be publishing the minutes. And so months were going by. And I think what ended up having to happen down there is the district attorney had to ratify all those meetings. He went through them, and over a period of 7, 8 months, they ratified those meetings because the law provided that they could not continue with their meetings without the minutes being there. So that was a problem. So yes, you need to have your, if they're required to be published, which I'm sure they should be here, they have to be published within a reasonable time.
I'm thinking about the journal record. You still have to record them in the journal record. For instance, the Town Talk is our journal. Can you do, as an alternative, like the website?
No.
That's still a no-no.
Not until the legislature changed the law.
Okay, I'm just curious.
Yes, sir. Now, minutes, once again, for a town thing, you don't have to record. Y'all probably doing it by television or by recorder or something like that. That is not required. That's at your leisure. You can make a decision to do it or not do it. Minutes have to be taken, but it's only certain things that have to be taken in the minutes. People present, votes, things like that. That's under, I believe, section 7.1. It says all public bodies shall keep minutes, written minutes of all their open meetings. The minutes to be kept by the well, that's different. They shall include the date, time, and place of the meeting, the members of the public body recorded as either present or absent, the substance of the matters decided, and at the request of any member, a record by individual member of any votes taken. Any other information that the public body requests to be included or reflected in the minutes. Now, if someone requests, like what this means is, there's only 2 times that you need roll call votes. Roll call votes, well, maybe 3 times, when you call the roll to who's going to be here. The second time is when you have a motion to amend the agenda, and then you need a 2/3 roll call vote. Now, what the legislature does and what other bodies do is, if it's something that's just trying to clean up the matters, usually I see the chairman say, without objection, so moved. And what can happen there, instead of going through all the roll call vote, the secretary should note in the minutes that everybody voted by roll call in the affirmative. The other time that you need a roll call vote is to go into executive session. And even though you have it on the agenda, going back, we're going to go into executive session, you still need a 2/3 roll call vote to go into executive session. Nothing can happen in executive session. You can talk, no votes taken. So what I suggest is when the chairman decides to come out of executive session, what should happen probably to keep the minutes clean is that someone makes a motion that we go out of executive session. You just have a majority vote to favor that, and then your minutes are all cleaned up. All right. Finally, we're going to talk about penalties, violations, enforcement. Oh, one other thing. Actions by the board. If someone is not pleased with the action by the board and claims that it was a violation of the open meetings law, certainly the easiest thing that I tell people to do is we find that out, and I talk with some people, is you go back and we say, let the board go back, review it again, and ratify its actions. And once the actions are ratified by the board, it clears it up. But I will point out that section 42.9 talks about voidability. And if someone takes an action, say the board takes a certain action, and someone thinks it was done in violation of the open meetings law, an action has to be taken within 60 days to void out the action by the board. So you can't kind of lie and wait 9 months down the road and say, oh, well, you violated something after the board has transferred all that stuff or money or whatever to take that action. Enforcement. Three methods of enforcement. Contact the Attorney General's office. We get a written complaint. 10 says the Attorney General, the District Attorney, and I know that I've talked with Jam Downs over here, and he is a strong enforcer of the open meetings laws. And then, of course, any person can bring the action themselves. Just for your knowledge, I was at the legislature this past week dealing with this stuff, kind of lobbying, I guess, for the AG to make sure we weren't completely wiped out. But certain legislators had some bills that would have, and it was passed the Senate, passed the House, House and Governmental Affairs, that would have made criminal 6 months in jail, $10,000 fines, violations of the open meetings laws and the public records laws. And basically our office killed this bill by putting a fiscal note on it that says that it would spread me out about 60 times and cost the AG's office about $10 million to have staff and stuff to try to enforce violations of public records, open meetings laws throughout the state. Now, certainly we have a traditional thing with civil remedies, and I think some of the thing is perhaps some higher penalties or something, but that's up to the court to decide, because the damages, that person who files a complaint can get an injunction to prohibit the board from doing it in the future, can get any damages he may incur, plus attorney's fees. So that in and of itself, I think, is a pretty good slap on the wrist. Plus, if the person, the board member, is in violation, he can't pass that off to the board to pay. It's an individual liability. So please keep that in mind. One of the things I would ask, and I know it's done, if you have questions about something, our office is always open. Give us a call. We'll be happy to say, well, I think this is the way it is. We don't know exactly what the law is, and there are always unique things that we talk about and say, I'm not sure. But I think if you get some direction or something, I think you'll be a lot better off, and certainly we're not going to be the ones saying, well, you did wrong after we told you what to do. Any questions? Thank y'all very much then.
Thank you.
We needed that.
Also, with Mr. Bro is Mr. James Downs, Rapid Parish District Attorney.
Well, I'm going to be brief. Mr. Bro has covered this well. I gave a few lectures on this subject in 2003 to various groups, clerk of court, judges, and the DA's Association, and I had a handout on that, so I updated it, and this is probably duplicative of what you've received, but I'll give you the benefit of what I have here. There are a few extra copies. I'll cover just one or two things. Mr. Bro mentioned there were 2 times that you have to have a roll call vote, and he correctly covered those 2 times. There's one other time that was not mentioned, and that is the Open Meetings Law statute provides that when any member of the public body requests a roll call vote on any issue that's being voted on, then you must have a roll call vote. That's it's not in Robert's Rules of Order, or if it is, it's in the statute. It's in the Open Meetings Law. So if one person says, I want the vote on the record, roll call, then the clerk must call the roll and have an individual vote on any issue. Doesn't make any difference whether you're going into executive, just any resolution, any ordinance, anything else. If a member wants a roll call vote and request on the record that a roll call vote be made, then that's the 3rd instance where you must have a roll call vote. There's a little confusion too about, you pass resolutions by, or ordinances by majority vote, which would be, in your case, 4 votes would pass something. Under Robert's Rules of Order, if someone abstains, that vote is not counted at all. That's not counted as a no vote or a yes vote. It's just not counted. So if 4 people abstain and 2 vote for the motion passes. 1 votes against, 2 vote for, motion passes if you have 4 abstentions. That rule does not apply when you have a 2/3 vote requirement. So if you're going to go into executive session, the law says 2/3 of the members present. So if you have some abstentions on a motion to go into executive session, those abstentions are counted as no votes. No vote. Yes, sir.
Charter requires us 2/3 of the majority of the entire council on most actions.
Well, that's an individual charter requirement. I'm just giving you the information on the Open Meetings Law.
Right. Would that apply in this case? It'd be more stringent than that requirement.
It may be more stringent, and it probably is more stringent. That's an individual charter requirement, which is city law, not state law. And I'm just addressing the state law portion of it. But on roll call votes to go into executive session, to add an item to the agenda, you must have 2/3 of the members present. So if you've got 7 people, you've got to have 5 votes, if my math is correct. So if one person abstains, you still have to have 5. 2/3 vote of the members present, because an abstention on one of those times when you're going to go into executive session, that's covered in this little outline I handed out. So this thing's got a lot of technical stuff in it. It'll be more benefit to your city attorneys, to Chuck and Trey and all of that. It's got a lot of citations, but the clerk may have some benefit to it. But we appreciate your attitude. I know that Charlie's worked hard on this thing, and I can tell you that, and I'm not going to take any more time, that these things come up from time to time. Most of the time, not following the dictates of the law, or not most of the time, or not times when people are trying to circumvent the law. Most of the time, it's out of lack of knowledge of the very technical requirements of the law. But it doesn't really matter, because if you don't follow the law, then what happens is you get, if somebody brings a lawsuit, whether it's Attorney General or my office or an individual citizen, and the judge puts penalties on you for not following it, so there's a $100 penalty for each violation that's got payable out of your pocket, and the attorney fees are payable out of your pocket. You can't get the city to pay that. So following the law is, that open meetings law is a very critical thing to do. And my office is open to assist you on that. I know I've talked to Chuck on a number of occasions, and Trey and some of the people. So if you need any kind of, I've spent a good bit of time on this, and in fact, one time during the previous administration, there was a zoning board, I believe, that was going into executive session to deliberate on the final decision on a zoning variance or something like that. But there's no provision in law to do that. So I had a complaint, a written complaint from a citizen, and so we wrote a letter to the employee or the staff member who was in charge of conducting those meetings for the zoning board, and really didn't get a whole lot of cooperation. So I prepared a lawsuit to enjoin that thing and all of that, and I sent a copy to the mayor and sent a copy of the lawsuit, and of course got good cooperation immediately. And the employee's no longer here, by the way, and so that was resolved, and the zoning board passed a resolution saying we won't do it anymore, and they posted a copy on the door where they hold the meetings, and the problem was solved, which is, after all, what we're here for. We're here to solve the problem, not to put penalties on people. But sometimes a suit or penalties has got to be done. So if it has to be done, it's our obligation legally to do that. But yes, sir.
One of the things that I think we need a little bit of a clarification on is the difference, and you and I have discussed this, because me personally lobbying each individual council member to support a position that I may have or something that I'm against, and violating the open meetings law.
You can't use telephone polling to decide any issue. Telephone polling is where you call around and say, what is your decision on this? But an individual council person calling another council person saying, how do you feel about this? I'm for this. I think this is a good idea. What are your ideas on it? Discussion one-on-one is not a violation of the open meeting law, but reaching a decision where one individual calls all of the other council members and conducts a telephone poll is a clear violation of the law. The other violation you can come into sometimes is what's called a walking quorum, and that is where you have a quorum, where you have less than a quorum, where you have 3 members of the council talking about business. Then another person comes in to that meeting. That would give you a quorum, and if you continue the discussion, you'd be in violation of the law. So one person who was there gets up and leaves, and you're down to 3 again. That's called a walking quorum. That's a violation if business of the city is being discussed, and meetings are not just times when you vote on things. You got to be very careful to understand that a meeting is also a gathering of a quorum of the council to receive information on a topic on which the council has jurisdiction. So if an expert comes in here to give you a presentation on something and you're receiving the information, that's a meeting that's got to be noticed just like any other meeting. And you can't do that with a quorum present without an agenda and without that sort of thing. Yes, sir.
So the Chamber of Commerce invites the City Council to its presentation on, annual presentation on economic development, and 5 city councilmen show up. That's a violation.
It is if the...
You didn't notice it, or all you have to do is notice it, put an agenda, say we're going. The only thing on the agenda would be to attend this thing to receive information.
I'm saying, let's say they didn't CC all the, they didn't copy all the councilmen on the letterhead, and I didn't know that 4 of the councilmen were showing up.
Well-
If I start seeing 3, then
Somebody
even if you leave, that's a walking quorum. But if you leave, that's a walking quorum, so that poses a
No,
problem.
if you leave, just leave permanently. Don't
Okay,
have
don't
more
come
than
back.
3 and don't.
That's
don't
interesting. I didn't
Come
know
back
that.
in there. But
That's
the easiest
interesting.
way to do that is when you receive information at a meeting like that, is just have the clerk put out it's just a letter thing that they fax to the media and post it on the thing here, and just say, attend meeting to receive information on this subject. You're not going to vote on anything over there, so you don't have to do all of that.
That's good to know.
And that way, you don't have a problem with it. It's a little bit of a nuisance, but that's the law. The legislature.
Oh, clerks are whispering now all of a sudden.
The clerk is on top of it now, and I think she'll do fine. I know Ms. Steele, she's very efficient and does a good job, so I think you'll be fine. So, but we appreciate the opportunity, Mr. Bowden and I do, to address you on this. If you have any questions about it, you may certainly call the Attorney General's office. You may call my office. We're there for you, and as I say, we talk to your city people all the time and be glad to do it. Happy to help you with that. We're here to help, not to cause problems.
Appreciate it.
Mr. Coleman?
Yes, sir.
What's the procedure as far as a private citizen or city employees, if they lobbying the council for something they'd like passed?
That, an individual may talk to any elected member of a body. There's nothing wrong with that. But you still can't, though, conduct no one can conduct a telephone poll if it's going to be, if a newspaper person said, how do you feel about this issue, or I'd like to get your position on this issue, if it's just a statement of position and not a decision that's going to be utilized by staff to do anything, that's not a violation of anything.
If they want something passed specifically.
That's the right of every public citizen to talk to their elected officials, to the mayor, to the members of the council, to try to convince them of the rightness of their position. So the law is not designed to thwart that. It's designed to prevent the officials themselves from getting together and deciding an issue outside of this room, except for the executive session that the law allows. Thank you very much. We're sorry we took so much of your time.
Thank you.
Thank you.
Gentlemen, we appreciate that. The gentleman noted that the public access through the televisions was important for their decisions coming here because they wanted the general public to acquire this information also. Thank you.
Where we at now? Consent calendar. Okay. Let's do the consent calendar.
I move.
Move second, all in favor?